Mira Real Estate LLC versus Nidal Zier. This is a property located on Millard Street in Three Rivers. Attorney Sumita Nagpal is here on behalf of the plaintiffs. The plaintiff, Mr. and Mrs. Patel, are also present. Apparently they own the Real Estate LLC. Mr. Zier is not. So let me see if he is outside here. This is a land contract forfeiture action. This property, I believe, is a marijuana dispensary, a Joyology. It does appear, at least to me, Ms. Nagpal, that more than 50% of the purchase price has been paid. Am I correct?
That is correct, Your Honor.
Are they still in possession of the premises?
They are in possession. They are conducting business.
What is the current arrearage?
Rashi, do you have the current arrearage? The amount owing as of now?
I can look it up.
As of the date of filing this complaint, Your Honor, it was $153,273.09, but that is.
Yeah, I have that figure.
Yeah. And we've also amended the contract twice, where the parties agreed that if there was a default in the payment, the land contract vendee would be responsible for $300 per month, late fees and reasonable attorney fees. And I think Ms. Patel is trying to.
Yeah.
Has anyone had any contact with Mr. Zier or anyone who's operating the business?
Your Honor, I have had contact with Mr. Zier's potential attorney. He hasn't filed an appearance. That's my understanding. However, they are not sure what they want to do here, whether they want to ride out the 6 months redemption period or whether they want to become current with the land contract payments. They are not sure, but they decided not to attend the hearing today.
All right, and as you're right, since there's more than 50% of the purchase price, the redemption period is 180 days. I don't have an order in here, so you're going to have to send me one. At the time of filing, make sure I don't have a notice hidden in here. I don't believe so.
Yeah, I can send the order today.
All right. As of July 1, the arrearage is $151,408 plus costs $153,273. That may be amended because we're now in almost October. They have 180 days to redeem the property. We're going to have to get through the whole winter. We've got October, November, December, January, February, March. It will be the 180th day will be approximately April 1st. At any rate, let me give you my email address. It's on the notice, but it's 3bcivil@stjosephcountymi.gov.
Thank you, Your Honor. I appreciate that.
Ms. Nagpal, I don't know if we've met. Have you been here before?
I have not, Your Honor.
All right, well, you can't get here from there. You can do it by Zoom. All right, well, this seems pretty straightforward. They've got the option to redeem it within 180 days, let it foreclose in 180 days, or work something out. At least there is some communication.
Yes, Your Honor, and I believe they are just waiting to see what they can do, what they can afford. If they can't, then they'll just ride out the 180 days and then get back the property. I think they're agreeing to that somewhat.
This is part of a reality that I've been seeing other places. There are too many dispensaries and they've saturated the market. And so the number of the smaller ones are struggling. maybe the bigger ones too. At any rate, I'll await your order. Defendant failed to appear. See default order.
I do have that updated amount if you need that.
Yes, that would be helpful to place that on the record.
Sure, it's 153,911.46.
That's through September.
Correct. And yep, that would be through September, and then that doesn't include this, so that's just the loan balance and no other like attorney fees or anything like that.
Yes.
Yeah,
Does that include the interest as well?
yes,
Okay, so Your Honor, that's just principal and interest. It does not include attorney fees and costs.
All right, well, the cost, the filing fee was $228
Mhm.
and $41.75 twice, which is 41.75 plus 40.75 is $83.50 in service costs. And your contract calls for reasonable attorney fees. The Landlord-Tenant Relationship Act said the attorney fee shall be $75. As archaic as that is. Plus 228. Total costs are $386.50. Those are $228 in the filing fee, $83.50 in the service fee, $75 statutory attorney fee, for a total of $386.50.
Thank you, Your Honor.
All right. I'll see you maybe again, but I'll await your order and I'll sign it.
Thank you very much, Your Honor. Appreciate it.
So I'm here. All right, thank you.
Thank you.
Mr. and Mrs. Patel, I'll remove you and you can go on about your business.
thank you.
All right, Mr. Thornton provides what's called a judgment form, which is very helpful for the court to understand what is alleged to have occurred. In this case, they allege that August rent balance is $1,201. September's rent is $1,395. There's a large late fee for September. They're claiming a total of $2,696.44. Plus attorney fee, court costs, and filing fee. The total is $2,933.84. Is that still accurate, Mr. Thornton?
It is, to my knowledge, Your Honor. That would include a payment of $400 that was made on September 19th. So if any payments have been made after that, I'm not aware of them.
I just made a $300 payment yesterday too.
All right, it may take a minute to clear. So your plan is to try to maintain this tenancy?
I mean, I would love to try to. I've been working, so every week that I get paid, I've been trying to make a payment, and then I've been in contact with Neighborhoods Inc. I've actually been waiting to hear back from her to see if I could get help getting it caught up.
All right. I've been complaining about this for a while here. They scheduled a meeting with all the funding providers, then they canceled it due to lack of interest. Well, I had lots of interest. I went to the meeting and nobody showed up. I
Yeah.
was hopeful I could get some information about how much funding they have and how much resource they have. October 1st is their new fiscal year, so hopefully they have some money. Mr. Thornton, in light of the fact they've asked for emergency assistance and we're going to go into October anyway, I think the law requires we continue this 2 weeks, which would be November, October 13th. Are you available at 2:15 on October 13th.
I am, Your Honor.
Now, my advice is almost always the same. Stay in contact with your manager. Let her know what's going on. Let her know if they need documentation from Neighborhoods, Inc. And let me tell you also, you have to pay the entire amount. Partial payment will not prevent the writ of eviction. This rent is very expensive, at least by St. Joseph County standards. And October 1st, you're gonna owe another month's rent. So you're gonna be almost $4,000 in arrears. So let's say they give you $3,000. You're still responsible for the additional $1,000 or you're subject to being evicted. So two things to keep in mind. October's rent is going to be added into this calculation when we come back. And you have to pay the entire amount to cure it. So you may decide, well, maybe I better move. We'll talk about that on the 13th. If you do move, I will tell you on the 13th how much rent is due, and it will be due 10 days from that day. So you're gonna have until October 23rd to pay the rent or be subject to being evicted. That's where the sheriff comes and puts your stuff out in the street. If you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. So you need to stay in contact with your funding, Neighborhoods, Inc., Ms. Wardell, and your landlord. And I will see you in 2 weeks, 2/15 on October 13th.
Okay.
Do you have any questions?
I don't think at this moment.
All right, I'll see you in 2 weeks.
All right, thank you.
All right, thank you, Mr. Thorne.
Thank you, Your Honor.
Megan is here. This case has had a couple of go-rounds, and let's call it. It's entitled William Wood and Marcia Wood versus George Wood. So George, would you have a seat over on this side?
Not, Your Honor.
What's that?
I said I would not, Your Honor.
All right, well, you can stand up. I don't care. And Marcia and William Wood are here. This file number is 251478. This is a family matter. And it's got some history to it.
Sir, I'm just moving.
You're just moving?
Yep, sir, I don't need the family problems. I'll get back title to my mom and dad and.
All right, well, let me call the case 251478. It's entitled, as I said, William and Marcia Wood. This is a property out in Roystown, Royce Place Road. For what it's worth, about 3 or 4 weeks ago, I drove out there. I wanted to inspect some property at a trailer park on Withers Road. And so I made a little spin through Roystown. I saw your girlfriend walking the dogs, and it was I don't remember, Friday morning, maybe, I don't remember. But anyway, I entered a judgment granting possession to William and Marcia Wood. And George wasn't here, so I entered it by default. George has filed a motion to set the default aside, waived the fee. He advised me just now that he plans to not challenge the termination and simply vacate the premises and move.
Sir.
So you don't wish to proceed with a motion to set
No, sir, I
aside
don't
default?
need it for my mom and dad. Mrs. Where's Joe gonna go, sir? I don't know about that.
What's
I
that?
don't know where the girlfriend you was talking about is soon to be my ex-wife. I don't know.
Oh, I don't know. I saw a lady walking a
Yeah,
couple of dogs.
that's my wife, but soon to be ex-wife.
All
I
right.
got the paperwork done.
She had two pit bulls.
No, they're not pit bulls.
Oh,
They're mixed, but
all right. Well, anyway, she was having a nice walk. She waved at me. She didn't know who I was from Adam's cat. All right, Mr. and Mrs. Wood, all along, you simply wanted this property back. Is that correct?
Yes, Your Honor, we're having trouble getting one of them out of there.
Who's still in there? Her?
Jody. This has been going on a year.
And
I
she
first
has,
started
she has the two
last year.
dogs.
Yeah.
All right, motion to set aside default is denied. Plaintiff or defendant withdraws motion. Which means she's subject to eviction.
Yes, I hope so.
Sir,
George, how soon will you be out of there?
Keep moving in with us.
I'm moving to my mom, dad.
All right, well, that's what you had proposed some time ago. All right, well, lift any stay. Property is subject to eviction. This is the house on the on the curve, the trailer back off there in the curve.
No, it's right around the curve. Our house is on the left side and the trailer that we own is on the other side.
All right, and then there's a bunch of like playground
Playground.
equipment and stuff in the front yard,
A what?
playground and bicycles and that sort of stuff in the yard.
Bicycle, no playground.
All right, I think I know which place it is. All right, the motion to set aside the default is denied because the plaintiff or the defendant has withdrawn it. Which means this property is subject to the original judgment, which means it's subject to eviction. So you should stop out and see the ladies about asking for a writ of eviction.
Okay. I've been trying to get her out of there since June of 2024.
Well, sometimes the law doesn't move very fast.
Amen.
All right, I'm gonna ask the court officer to take you out.
Where'd you go to school at, Your Honor?
What?
Where'd you go to school at?
I went to Three Rivers High School more than 50 years ago. And I made it as far as Centerville. I lived in Detroit for a few years, but I never really left St. Joe County.
For your
Wayne
degree.
State University in Detroit.
Yeah.
3 years in Detroit was quite sufficient for me.
4 year.
All right, thank you. You're all good to
Thank you, Your
go.
Honor.
Mr. Everett Valancourt is here. There are two files, 2564 GC, which is entitled LVNV funding versus Everett Valancourt. The defendant has asked for an installment payment plan. 231555 GC is Jefferson Capital versus Everett Valancourt. He has filed a motion for an installment payment plan. So we have two different creditors. Fortunately, both creditors are represented by attorney Andrew Katz here with us today.
Yes, sir. Hello. Sorry about the inconvenience on this.
All right, Mr. Katz, Mr. Valancourt has several other matters going on. He has an eviction case, which is scheduled for November 13th. That's 252002 LT. And so it's Golden Pond Estates is seeking to collect rent or have a move. He also has a criminal case. Mr. Valancourt, you have court set for 2 days, October 2nd. As long as you're here, I'm going to take care of that matter also. That is an operating while intoxicated second offense. But you are here to discuss these two installment payment request cases. As the problem in most cases is they don't have any money. In LVNV funding case, let me flip to the judgment.
Your Honor, if I have a difficulty where I'm not allowed to leave, is it okay to place a telephone call to Ms. Lentz to let her know to have someone retrieve her grandmother's vehicle that is borrowed?
Well, you're not going to jail today. This is a civil matter.
Okay,
Anyway, the judgment entered July 25th for $1,230.99. The Jefferson Capital case, I think, is bigger than that.
Total
Judgment
balance
entered
on
in that case in the amount of $3,690. That is file number 231555 GC. So, Mr. Valencourt, are you using
Yes, sir.
chew right now?
No, ma'am. Or no, sir. Sorry. Allergies. Stuff that comes, I have fluid buildup in my lungs from working in the
Like to
installation.
use a spit bottle while we're here in a live proceeding. Mr.
Okay.
Katz, and Mr. Valencourt doesn't have any money. He's asked for an installment payment plan on both of these. If you're willing, I'll put you in a breakout room where you can discuss these issues with him. And
well,
I'm
Your
not
Honor,
sure.
just to head things off, both of my clients have reported to me that they have no objection to the installment payment
Oh,
motions as they were written. So I
all right,
unfortunately
well, then
I
let's,
don't have each in front of me right now, but I do have that.
all right,
Neither of my
in file 231555, he offers to pay $70.50 each month. Is that correct?
Yes, sir.
All right. So in file 231555 GC, I'm going to grant the motion for installment payments shall be paid $70.50 every 2 weeks, starting November 1.
You cannot do it every 2 weeks, Your Honor, sir. I have limited.
Excuse me, every
disability.
month. I'm sorry, every month is what you said. 2025. $7.50 every month, starting November 1st, 2025.
I do apologize for this, Mr. Middleton. The time that these bills were acquired, Ms. Lentz had taken necrotizing fasciitis from bacterial fluids that belong in a particular part of your body from where she had a bladder mesh installed. The wire cut through everything and the vaginal fluids were leaking into her leg. And basically all my funding and then her lawsuit money went into paying for medical supplies. And then we
Right,
just.
well, that can happen. Sneak up on people. All right, that's the LV or
like
Jefferson
the
County.
defendant just
All right,
said,
just a
she
minute.
will pay the balance at $15 a month. We will start that payment program on November 10th.
LVNV funding.
Yes, Your Honor.
7050, same thing. LVNV funding. 7050 a month.
Thank you, Your Honor.
Just a minute. I have the order here somewhere. $70.50 every month. We'll do November 15th. One's November 1st, the other's November 15th. What's your source of income?
Social Security disability, sir.
All right.
That is why when she took sick, that the funding that she received from the $100,000 of her bladder mesh thing went to paying most of her medical bills post receiving the checks for her out of court settlement, which I actually was going to settle the case for $750,000, but Ms. Tara thought $100,000 more than.
I'm not
$750,000.
sure. Who are you speaking about?
Ms. Lentz, when she got the necrotizing fasciitis from a faulty bladder mesh installation in her body, the
All
time of
I
necrotizing
don't know that
fasciitis.
I don't really want to air all her medical business in
Well,
here.
that was the inconvenience and not being able to pay the LBNB and the other thing. She had taken like deathly ill, and the funding from her lawsuit money and what income came in went to pay for her medical supplies and
Well,
healthcare.
that's her cost, not yours. So you agree to pay $70.50 each month on each of these accounts. One would be due on the first of the month and one would be due the 15th of the month. You understand?
Yes, sir.
All right, plaintiff did not object to your motion in each case.
Thank you.
And you can go out to the counter in just a minute and pick a copy of these orders up. All
Okay,
right.
thank you, Your Honor.
All right, Mr. Katz, I think we're okay here. I've got to deal with some other business with the defendant, as long as he's here. And thank you. I'll see you next time.
Thank you, Judge. And the court will send a copy to the plaintiff's.
I
Correct?
did. I signed both orders and you'll get copies.
Thank
All
you,
right,
Your
thank
Honor.
you.
Have a great day, sir.
Thank you. All right, Mr. Valencourt, you've got court scheduled on October 2nd. You're here live now, and I'm gonna do this. I'm gonna do it without a public defender because I'm simply gonna recommend that you plead not guilty and get an attorney to assist you. The allegation is that on June 30th, you were operating a vehicle here in St. Joseph County while you were intoxicated as a second offense. That is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. It carries 6 points on your driving record and requires that your license be suspended. That hasn't made it into my queue yet. I'm going to recommend that you plead not guilty and I appoint a lawyer for you. Do you have any objection to that?
No, sir. If that's what you feel is best, we'll go with that for the time being.
All right, very good. I show a plea of not guilty. I'm going to appoint an attorney and set an attorney pretrial for November 7th, 2025 at 8:30. Mr. Valencourt, I'm going to send you out to the counter. You can get copies of the 2 installment orders that you just entered into. And we're going to give you the court-appointed attorney paperwork regarding this drinking driving case.
Yes, sir.
It could affect your driving privileges. It could affect your insurance, could affect your, you could end up incarcerated for it. So I think it's important that you get an attorney. I can't get it to come into my system yet. But I think the safest bet is to get an attorney. So now they're going to give you the paperwork with the attorney's name and number on it. I want you to call that attorney and make an appointment to discuss the case with them. Oops. Prior to November 7th. They'll get the police report and other information. If there's any body camera videos or anything like that. And to be prepared to further discuss this case. Are you on probation or parole anywhere?
No, sir.
Very good. Can we still use the Youngman Road Lot 33
Yes, sir.
address for the time being?
Yes, sir. I have to go next door after I'm dismissed from here to put in a change of address. They have it at the Keystone place. I'm back with Miss Tara and at the residence at the Youngman Road Trailer Court.
All right. Well, they say that this happened on 131.
Yes, sir. Head north. back to Three Rivers, out, or to Three Rivers, back to the Young Men Roof Trailer Court.
Don't say anything about it. Don't say any more about it.
All right,
But, all right, we'll get you a lawyer. So I want you to go out to the
Okay.
counter. We'll give you some paperwork regarding your civil cases, your motion for installment payment, and your criminal case. Now, that means you don't have to come back here on October 2nd. Your next court date
Okay.
will be November 7th at 8:30. So you go out to the counter and the clerks will take care of you from there.
okay, thank you, Mr. Middleton.
All right, good luck, sir. You got a lot
Have a
going
wonderful day,
on.
sir.
All right, I guess the next time I see you will be in the landlord tenant case. But,
Yes, sir.
okay, very good. You're good to go.
Thank you so much. Have a wonderful afternoon, sir.
We're working on it. Our next matter is Block 14 Inc. versus Pauline McDowell and all others, which include Joseph Tullis. They're here with me from their mobile headquarters, and Jeremy Gump is present. Also, he represents Block 14 Inc. We were here previously on September 22nd. The defendant indicated they wish to move and plan to move by October 1st. We continued the matter until today. Ms. McDowell, what's the situation here?
We've been moving stuff out this past weekend. We're about almost halfway there. So I just need just a few more days to finish getting everything out so I can just get the apartment cleaned up and the keys handed over.
Well, the law says you get 10 days from today to move. My hope was you'd be out by October 1st, so they wouldn't have to deal with the issue of October's rent. But nonetheless, you're agreeing to move. I'll show it as a consent that you agree to move. 10 days from today
Okay.
is the 9th of October. No money judgment is entered at this time. You also have 10 days to appeal this. I think our instructions last time were just leave the keys on the counter. But when you move, you also need to turn in your forwarding address in writing within 4 days of your moving. This is a possession only judgment. It's not a money judgment. If they come back and seek money damages, we'll have a subsequent hearing to figure out who owes who how much money. But at this point, you have 10 days from today to move or you're subject to being evicted.
Okay.
Make sure you leave the keys on the counter. And what town are you moving to?
It's still here in Sturgis. It's just to the other side of Sturgis.
All right. Well, you need to provide your address when you do move in writing. All right. Do you have any questions?
No, that sounds good.
All right, you're good. And Mr. Gump, thank you for sending me a judgment. We're all good to go. I've signed it and they got 10 days to vacate. Very good.
Thank you, Your Honor.
Thank you.
Thank you.
We were here previously on the 15th of September. We adjourned the matter actually for 2 weeks until today. We determined at that time that defendant's rent was substantially in arrears, $6,075 plus court costs for a total of $6,337.50. Rent is $1,300 per month, which by St. Joseph County standards is pretty high rent. Ms. Sprague, what's the status now?
Your Honor, we do show that the same figures remain, which are $6,075 for prior rent, as well as court costs in the amount of $262.50 for a total due owing of $6,337.50.
Of course, in a couple of days, October's rent will be due, which will add $1,300 to that.
Yes, Your Honor.
Mr. Ashbrook, what's your position here?
I am getting starting the process with the HARO program. I was denied through DHS due to not having proof of no child support, and I was denied from community action due to my past income exceeded their allowed limit. So I spoke with Carolyn at the HERO program today, and we are getting the process started. I've been in contact with her throughout the last 2 weeks.
Well, do you have a job now?
Yes, I start a new job at Precision Speed here in Sturgis this week. Tomorrow is my orientation.
All right, well, your rent is gonna be almost $7,500 in arrears. I doubt that Neighborhood Inc. is gonna give you that much rent. Let's say, for the sake of argument, they give you $5,000.
She
You
did-
still owe additional $2,500 or be subject to being evicted. So I don't know. That's why I adjourned this matter 2 weeks, because you were seeking help. It hasn't come forward. You've contacted all 3 agencies that we're aware of. But I'm gonna go ahead and enter this order. And then you can take the actual judgment with you to Neighborhoods Inc. Ms. Sprague, I don't have a judgment in here. If you would email me one.
I can get that sent over in about 5 to 10 minutes, Your Honor.
All right, and so it will be those numbers.
Your Honor,
6,075, 26250. For a total of 6,337.50. Now, Mr. Ashbrook, theoretically, that's due within 10 days or you're subject to being evicted. Sir, would you land in one place? You're making me dizzy.
Okay, sorry, I was trying to get a pen to write this stuff down.
All right, well, you can watch the YouTube and help refresh it. Anyway, you may also figure there'll be another $1,300 for October's rent. You have until 10 days from today, which is October 9th, to pay the rent or be subject to being evicted. Now, this is important, so listen carefully. They don't have to evict you on October 9th. They have 56 days from today to ask for the writ of eviction, and in fact, another 56 days to serve it. So if you're going to get help, they can agree to work with you to try to get caught up. But your rent is way behind. Frankly, I don't think you can afford a $1,300 a month apartment. Even when you get back to work, I don't think you can afford a $1,300 a month apartment. But that's not up to me. So it's important that you stay in contact with Miss Wolf, your manager.
Okay.
I'm gonna sign this order in just a minute that says you owe that amount of money through September plus $262.50 in costs due within 10 days or you're subject to being evicted. The worst case scenario would be the sheriff would come put your stuff out on October 10th with an eviction order. So it's important that you stay in contact with your manager.
Okay.
Your Honor, if I may,
Yes.
we did request a money judgment. If I could put those numbers on the record, and then I'll get that judgment sent over.
The problem is it doesn't have October in it. And if
Okay.
you do a money judgment now, you're stuck with it.
All right, Your Honor.
I'll do it if you want me, if you want me to, in those numbers, but it won't have October in it.
Ms. Wolf, would you like us to request a secondary hearing?
I think so, because that
Okay.
doesn't allow for damages either.
Okay. Your Honor, we're content with the possession then, and we'll reserve the issue of money damages.
All right, very good. All right, Mr. Ashbrook, I wish you luck. If you do move, let me tell you what I told you last time. You need to turn in your keys and give your forwarding address in writing within 4 days of your moving. So
Okay.
I wish you luck,
Thank you.
Miss. All right, you're good to go. All right, Ms. Sprague, thanks for your help. Ms. Wolf, He'll be talking with you. As I said, I'm not sure he can afford to live here, but we'll see how it plays out. Thank you both.
Thank you, Your Honor.
We're gonna return to a small claims matter we heard some time ago. Mr. John Auer of LaGrange sued Furniture and Mattress Warehouse in Sturgis. The file number is 251506SC. Mr. Auer ordered a California King mattress, which he later became dissatisfied with, and he sued the company for $900.99. Carrie Kling is here on behalf of the company. We were here previously, and the company agreed to talk to their mattress supplier. And so we continued the matter. Ms. Kling and Mr. Auer, would you both please raise your right hand? Do you both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
I do.
All right, Ms. Kling, I'll start with you. You were very gracious when we were here last time. You agreed to inquire further with your warranty regarding anything. What were you able to find out?
So my husband and I did go out a couple days after the hearing, and we took pictures. We checked the mattress over. My husband even laid on the mattress, and I submitted all the emails to CERTA, and they came back and there's no defect. Basically, they would have to find an 1.5 inch sag on a quilted top mattress, and there is no sag in this mattress at all.
And is this the exact mattress that he ordered?
Yes, it is. Yes. Yep. And I sort of did, I didn't talk a whole lot when we were there, just due to having a court case. But I sort of did indicate, when I was there that we really just didn't see anything wrong with the mattress at all ourselves even. But, I wanted to do our due diligence and send it on, and have them decide with the pictures and stuff. So.
Mr. Auer, what's your position?
Well, I would say that they have a vested interest in saying that everything is great. But I'm the customer, and somewhere along the way, I used to be the customer was always right.
Well, maybe it used to be, but this is a purchase of a product, and it has not met any warranty defect. You ordered it specially, you got it, you didn't like it. They gave you exactly what you ordered.
Wait a minute, excuse me.
Yes, sir.
The only evidence that there's no warranty defect, it comes from them, and they have a vested interest.
All right, well, you're the plaintiff. Prove to me that there is a defect, other than you say I don't like it. You have the burden of proof, not them. They don't have to prove they didn't do it. You have to prove that they violated the warranty. So all I know is that you're not comfortable in this bed.
Okay, the most solid proof I have is when they sent out two of their people to check on it the first time. The one man pushed down on my side of the bed. He said, "Oh, that's soft. That's too soft."
Well, for one thing, that's hearsay. That person would have to come in and testify that it was too soft. But I don't find you made a claim. They bought exactly what you ordered. They had to special order it. They don't keep California Kings in stock. I just bought a mattress. I went through the whole process of laying on 55 different mattresses, and I bought one which was delivered on Saturday. I've yet to sleep in it. That particular company offers a 100-night guarantee, and it's not really a guarantee. They'll just apply it toward a different mattress. I don't find that you've met your burden, and I'm not ordering that they pay anything. They went above and beyond, went out to your house, took pictures of it, examined it. You're right. They have a vested interest to show that there is not a defect. you have a vested interest to show that there is, because you want your money back. But I don't find that you've proven that it is defective, other than you don't like it. All right. I find for the defendant, I think you got just what you ordered, but once it got there in your house on your box spring, it just wasn't right. Maybe you should give it some time. It sounds like a very nice mattress. Anyway, I'm not ordering that they pay anything. And if you'll take him out to the counter, he can get his copies. So we're gonna return to the matter of Centerville Mobile Home Park versus Craig Kloppenstein. And I always forget, I say it both ways. You say Kloppenstein? Yeah. All right, and you've heard me mispronounce it many times, but I'll try to get it right. He's here with his attorney, Megan Bauer from Legal Aid of Western Michigan. Attorney Dana Hull is here on behalf of the mobile home park, as is their local manager, Joshua, and their regional manager, Christy DeCenzo. The parties have been in varying discussions. This was originally filed as a demand for non-payment of rent, $403 a month, first of each month. At the time of filing in August, the arrearage was alleged to be $771.88. It's gone up since then. We are all still struggling with the fundamental question of whether you can even bring a non-payment of rent action in a mobile home case, but this court has been allowing them. Plaintiff had supplied a brief that they'd written in another jurisdiction. I've seen several briefs in favor of the proposition and a couple of rulings by different courts that have outlawed the practice. At any rate, I'm proceeding as though we can do this as a non-payment of rent. Then they filed some pictures which seem to have to do more with the termination of tenancy issue. Attorney Bauer raised a number of issues, and this is complicated because it's lot rent, there are taxes, utility costs, late fees, very high late fees, and it's also a rental purchase option. So some of the money's going to the actual purchase of the mobile home. So I'll defer to you, Ms. Hall. What's our current status?
Your Honor, I spoke with Attorney Bauer in a breakout room. We were going to we're close to resolving the issue, but we were going to request another adjournment to see if we can completely resolve it. The photos that were sent, the reason for that was that they were disputing the lease violation fees. So that's why I included them in a non-payment of rent case.
All right, I got it. Ms. Bauer, what's your take here?
Thank you, Your Honor. Ms. Hull is correct that we've spoken in breakout session and that we are working towards resolution. At this point, the defense is fully ready, willing, and able, prepared to settle the entire matter for $1,731.90. That represents what Mr. Kloppenstein has tried to pay to the park. That represents the balance that the plaintiff has presented to us, minus $525 in late fees, which we construe to be unenforceable liquidated damages clauses of the lease agreements. They are not reasonably calculated to accommodate for the damages suffered by the landlord. Therefore, they are penalties, and Michigan law is pretty clear that penalty clauses in contracts are unenforceable, that they're unenforceable liquidated damages clauses. We dispute the $185 violation notices on two grounds. One, the lease, there's no reference to which paragraphs of the lease Mr. Kloppenstein has violated. So yes, there is provisions in the lease for violation fines. Again, those should be subject to the same liquidated damages clause test. They have to be reasonably calculated to account for the damages suffered by the landlord. Whether Mr. Kloppenstein has committed the conduct alleged would be a question of fact. Whether they have undertaken the necessary steps to trigger that violation clause would be a question of law for the court. Again, they have not cited in the lease violations which paragraphs of the lease he violated. One of the clauses in their lease allows 30 days for remedy. They didn't provide that. And because all of this was precipitated by Mr. Kloppenstein, I'm sorry, we just had that conversation. All of this was precipitated by Mr. Kloppenstein's inability to pay, because their payment system will not allow him to pay anything but everything the park is demanding. So if the park were to demand $1,000 and he tried to pay, he disputed that and he tried to pay it, he would be prohibited from that. So that gives them an absolute control to extort money out of tenants, including these $175 late fees. And there's a series of letters from the park threatening, if you don't pay, you're going to be evicted. Eviction will have a long-term history, a long-term effect on your rental history. This is an embarrassing procedure that you don't want to undertake. We have that kind of stuff in writing from the plaintiff. All to say, had they just allowed Mr. Kloppenstein to pay his rent and not these violation fines and work them out, we wouldn't be here. So there'd be no basis for court costs either. He has repeatedly attempted to pay his rent and it's been rejected by the plaintiff in a non-payment of rent case. That said, the defense would like to seek amicable resolution with the plaintiff. The plaintiff has proposed an adjournment. So at the court's discretion, we would be amenable to adjourning toward resolution. There are some other issues I raised previously I haven't stated here. For example, part of the money that they're seeking that we have agreed to concede, $95 a month in home rental fees, put forth in a purchase agreement that does not name the plaintiff. So there is a necessary party that the plaintiff has not included in these pleadings. Just reading from the first paragraph. This purchase agreement is entered into by and between Craig Kloppenstein and Gretchen Anderson and Fisher Homes LLC, hereinafter referred to as the mobile homeowner, and is effective as of the date of signing. And then there's a separate LLC mentioned in the very next paragraph. So the plaintiff is not a party to this purchase agreement, has not demonstrated its ability or right to collect $95 a month from Mr. Kloppenstein for 48 months. But Mr. Kloppenstein is willing to concede that argument and settle the amount and settle the claim for the $1,732 that he has accrued in rent and utilities that he's tried to pay.
Would those $95 payments be applied to the purchase price of the home?
Yes.
All right. There's all kinds of problems here. And eventually when the new owners get their footing and everybody's on the same lease, and things will be better. You can't charge $175 late fees for a lot. The law on late fees is very unclear. As long as we've been dealing with it, at some point it becomes a penalty And you can't establish I don't even allow $100, but you can't do 75 after the first of the month and $100 after the 15th of the month on a $403 lot. So there are problems there. There are problems with violations of the Landlord-Tenant Relationship Act, perhaps with some of these threatening letters. There's the issues regarding the lease violations. Theoretically, and heaven forbid, I don't want to have a trial every time someone's involved. They claim you violated your lease and you claim you didn't. There's also this odd phenomenon where the defendant can only pay the entire amount of rent plaintiff claims without having the ability to contest anything. So there are multiple issues. What is the current amount plaintiff is claiming? When we were here last, we were at $2,441.90 and $170.05 for a total of $2,611.95. Defendant contends, I was prepared to pay my rent each month. Plaintiff wouldn't accept it. So I shouldn't be subject to late fees, and I shouldn't even be subject to this lawsuit, because if they accepted my rent, they wouldn't have had to file the case. I'm not sure that's gonna fly, but at any rate, I don't want to have a one-day trial over $900 difference. He's offering 1,731. You're offering 2,611.95. We're about $900 apart.
Yes.
And I can set a one-day trial. I'm not sure that'll even be long enough. But I do appreciate the fact you guys have been doing some earnest discussions. Of course, on the 1st of October, another month's rent will be due. Yes?
I just had a question, but I can.
Okay, go ahead.
Well, the letter, there's a lot of documents that I sent over, so I'm just wondering, what are we referring to with the threatening letters? Because I see the lease violation notice.
I have not shared. I'm sorry,
Yeah.
Attorney Hall. I have not shared this letter with you or the court.
Well, you quoted from it.
I did, that's correct.
Okay, well, you could send it to me when you get a chance. I just hadn't seen it, so that's why I was wondering what we were talking about.
Is there a date on it?
There are several letters. July 25th, 28th, and 30th, each of which indicates final notice, but
who are they from?
Centerville Mobile Home Park LLC. The one I was referring to specifically is July 14th.
Okay, well, I would just like to see them if you get a chance while we're.
Yes, I would. I ask you to provide copies of that correspondence to the plaintiff's counsel. I also discussed doing an escrow order where I would hold on to the money.
The defense has no objection to an escrow order.
All right. Escrow order 1,731.90 and 403 per month after October 1. Mr. Kloppenstein, I don't disbelieve that you've got this money set aside, but I always feel better if I'm holding on to the money, because a car insurance bill comes due or your refrigerator breaks and you spend the money somewhere else, and when it comes time to pay up, that money that was set aside got spent. So I want to hold on to it. And so I'll do an escrow order for the original agreed upon amount that by the defendant, $1,731.90,
How can I pay that?
right here at the courthouse.
Okay.
We'll take cash, credit card, money order. We're not doing crypto
I
yet,
got
but
cash in my debit card.
all right, and you can put it on your credit card and make that payment. So let's see where we want to move this to. I don't. Oh, I blocked out the whole day on the 17th. I've already got, how about 1:30 on Friday, October 10th?
I can do that. Anna.
Does that work for you, Miss Bauer?
October 10th is triggering something in my mind.
We've got landlord tenant in the morning. The afternoon is presently open. I'm gonna be gone a little bit in October. For medical things.
It does appear to be open on my my work calendar.
All right, well, let's continue this to Friday, October 10th at 1:30. If the parties can come to a resolution in the meantime, great. We're really not all that far apart. Just as a starting point, you can greatly reduce the late fees. Also, there needs to be some sort of a new agreement. So Mr. Kloppenstein knows when he's paying his $95 that it's going to where it needs to go to. And again, once everything gets on level ground. Yes. That's the part where I said, Shane, I have your jail arraignment.
Oh, I'm sorry, I can't hear out of
What do I do with it? There it is. All right, Friday, October 10th at 1:30. I'll try to leave time. Again, I'll do what has to be done. I don't want to spend 4 hours arguing about $800, but I will if we need to. I'd like to bring closure to this on that day.
Judge, I would just point out, it may not just be a matter of paper shuffling. If the plaintiff doesn't own the home,
Yes.
then they can't sign a new agreement selling it to him. But I know
Well, that's a wrinkle. So
down the
he's in a precarious position. He's willing and ready to make the payment on it to acquire ownership of it. But if a plaintiff doesn't own it, anyway.
I know, Judge.
And that's not even part of this. This is just lot rent.
It is part of what's assessed.
All right, well,
All right.
if you can figure it out. Anyway, we'll do an escrow order that will be after October 1st, 1,731 plus 403 for the month of October. So the total would be 1,731, all right, 0.90 plus 403 is 21,34.90. You can pay 17.90 today and then 403 after October 1st. All right.
That's 1731.90.
1731.90.
Okay.
All right, they may not be able to accept it yet because they haven't done the order, but we'll see. All right, thank you all for working on this. Let's see if we can get somewhere, but we'll address it further on Friday afternoon, October 10th at 1:30. All right, you're
Okay.
good.
Thank you, Judge.
If I may,
Yes,
Connor,
We want him to clean up outside. Is there any way that's what this is really all about?
Judge,
Right.
this
Right,
happened
yeah.
last time,
No.
and I'm
Yeah.
going to object again.
Yes, you have a lawyer and the pictures outside look messy. Do you have any cats?
Yeah, I got one outside cat.
All right, because he's had a cat issue at all of his previous tenancies, so I don't know about that. Well, if you want him to clean it up,
He
then
has
file
more
it
than
as a
6 cats.
just cause termination rather than a non-payment of rent. He likes cats. They're a part of his identity and comfort to him, and it often causes stress for the neighbors and the landlord. So I hadn't heard anything about cats, but I expected they're under the radar. Yeah, if you want to do that, file a termination of tenancy. This is only about the rent.
Yes,
Uh,
we talked with,
All right, you guys can discuss that further.
okay,
All right,
thank you.
Great.
all right, I'll see you all on the 10th.
Okay.
Thank you, Dana.
Thank you.
Okay, I'm gonna meet you back.
All right.
Yep.